name is Jacob Mwele, advocate. I'm here with Wakili Julius Enyoka and counsel here, the county attorney, Erasta Zorina. We are the team which is representing the governor. As you're aware, the assembly last week on 27th, a notice of motion was tabled seeking the removal of the governor through impeachment. We had come here to give our response before the assembly, and we appeared before the assembly, what we thought was a committee of the assembly, to clarify the issues. We've submitted our comprehensive response to the issues which were in the motion, and we did attempt to ask for an opportunity to take the committee through point by minute explanation of the response as it is required, understanding order number 65, but that opportunity was not given to us. I don't know for what reason we were not given, but what we are saying is that this motion does not meet the standard of Article 181 of the Constitution. There are two grounds for impeachment here. One is a gross violation of the Constitution and the law, and the other one is abuse of office. The 80% of this motion is drawn from the audit queries, which emanate from this year's audit. These are the report of the Auditor General, which has just been tabled. So this report has not gone through the processes. It has just been tabled in the Assembly and in the Senate, and it has not even been considered by the same committee of the Assembly. So we thought that this committee should be given an opportunity, that is the Public Accounts Committee, to go through those audit queries. And if they have been clarified, then most of these issues will be resolved. The other 20% arises from issues which are in court. We have furnished them with court orders. These are matters which offend Standing Order 87 of the County Assembly, that these are matters which are sub judice, and we have raised it before the Assembly. And so we expect that today in the afternoon, we'll be accorded an opportunity to take through the Assembly, through all the allegations, we counter them. What we are saying is that this motion does not meet the standard for impeaching the governor. So I'll allow my colleagues also. Well, there was a miscommunication on the part of the Assembly. If the Assembly indeed wanted us to give copies to all the members, we could have done that. But the letter which we got was only inviting us to come and do a response. And we went out of our way and generated 5 bundles of documents with annexures, which is submitted today morning to the office of the clerk. So had they asked us that we submit 35 copies, we'll have done that. So it's basically a miscommunication that if they really intended or wished to be furnished with those 35 copies, we would have submitted the copies. And basically when we gave it to them, they were trying to photocopy, but their machine broke down. So these are just administrative lapses, which we take responsibility, all of us, for both sides. But the point is, if you have an opportunity to look at our response, the issues which are there, 80% of them are from the report of the Auditor General. They are audit queries, which have not even been resolved by the Senate. They have not even been resolved by the Assembly. So you cannot impeach somebody on the basis of a draft, on the basis of the audit report of the Auditor General, which has not gone through the procedures as per Article 226 of the Constitution.
Lastly, you said
we never received any invitation to appear before the committee. We thought we are coming to the Assembly to debate. So that miscommunication about it, there is no even requirement about 24 hours, but it is in good order to furnish the responses on time.
Thank you.
Yes.
First of all, the members of the Fourth Estate and the public, I believe you are all present in the Assembly. That is the committee session. You witnessed the proceedings. What maybe surprised us is that it appeared, and that was something that was captured by everyone, that the movers of the motion were not serious about the substantive aspect of the motion. So much that the members or the movers of the motion dwelt so much in technicalities which mostly are administrative, which do not go to the substance of the motion. The reason being that after evaluating the motion, it's substantively clear that the motion is grounded on very weak points. It does not meet the threshold of removal of a governor. When you talk about gross violation, that means extreme negative action on the part of the governor. However, for those who have had the opportunity of associating themselves or maybe having the opportunity of reading or perusing the contents of that motion, there is no single allegation that touches on the governor, either his office or as an individual. These are generalized allegations. Most of them are hearsay. They're not based on any specific allegations or evidence. Now, most importantly, we had come as representatives of the government, which is allowed by the standing orders. We expected to be given an opportunity to make oral submissions to address issues in the rebuttal that have been raised in the motion that was before the Assembly. However, that was not accorded to us. That notwithstanding, we are confident and positive that the submissions or the response that were placed before the Assembly meets the threshold and responds to all those issues that were raised in that motion. Now, on the other aspect of issue of copies, we have had similar sessions before the House Committee where we have not been required to supply copies to each and every member of that committee. There was no indication. It's only today that was raised that we are to supply copies. That was not really anticipated by anybody, including those movers of the motion who only elected to cling or hang on that small aspect of a procedural technicality or administrative lapse or gap. However, as you are all aware, we finally managed to supply them copies, and as they are retiring in the afternoon to debate, that is before the whole House, I appeal to all members of the Assembly. They should put the county interests at heart. They should carry the aspirations of their voters and electorate. They should not personalize. It should not be a basis for witch hunt. They must be held to account. They must account for future generations. Impeachment is so serious a proceeding, so much that owners of such proceedings must be indeed committed, both by heart and spirit.